From the very start, the atmosphere is tense. Mr. Justin Starkey is about to admit he's guilty of very serious crimes, like attacking a police officer and throwing bodily fluids at jail staff. These aren't small mistakes. They're major crimes called felonies. This isn't just a traffic ticket or a bad choice. This is violent and intentional behavior that could land him in prison for years. So when the judge starts asking what may sound like simple questions, don't be fooled. They're leading up to a big legal outcome.
Are you satisfied and happy with your attorney?
Yes.
Mr. Keene, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Mr. Starkey, are you admitting here today that you in fact did batter or injure a law enforcement officer?
That's what I've heard.
And you didn't have consent to do so?
No.
And are you admitting here today that you in fact did throw or expel urine at a...
Yes, you heard that right. Starkey admitted that he purposely threw urine at a corrections officer. Gross? Definitely. But it's also a serious crime in Wisconsin. It's legally called prisoner expelling bodily substances, and it's a felony. This kind of act isn't just nasty or rude. It's a health risk and a violent attack. The courts take it very seriously, especially when it's aimed at jail staff.
Corrections deputy?
Yes.
And you didn't have consent to do so?
No, I did not.
All right. Do you have any questions for the court or for your attorney before I proceed?
I do not.
Okay. Mr. Keene, did you go over the facts alleged in the criminal complaint with Mr. Starkey?
Yes, Your Honor. Went through all four of them, and more recently, 24 CF 91 and CF 109, along with, we reviewed them on the 4th as well.
All right. And did you go over what the state would have to prove, those elements as they apply to the facts?
Yes, Your Honor.
Or as the facts apply to the elements, actually?
Now pay close attention. This is where a lot of people get confused. The judge says the other charges are dismissed and read in. That might sound like Starkey is getting off easy, but that's not true at all. Read in, charges don't disappear. They're still taken into account when the judge decides the punishment. Think of them like a shadow in the courtroom. Not listed as separate crimes, but still affecting the final sentence. The judge knows the full picture, and the punishment will reflect that.
Did you also go over his constitutional rights and what it means by waiving his rights?
Yes, Your Honor.
And did you go over the strengths and the weaknesses of the cases with Mr. Starkey?
Yes, Your Honor.
And do you believe he's entering his pleas freely and intelligently and voluntarily here today?
Yes, Your Honor.
And do you believe he's entering his pleas competently here today?
Yes, Your Honor.
Do you have any concerns about your client entering his pleas here today?
No, Your Honor.
All right. Mr. Starkey, one last time, do you have any questions before we proceed and before I have you enter pleas today?
No, I do not. I do not have any questions.
Then as to count 1 in 24 CF 91, battery to a law enforcement officer, and H felony, how do you wish to plead?
Guilty.
As to count 1 in 24 CF 109, prisoner throwing or expelling bodily substances, and I felony, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of those 2 charges. The remaining charges in those cases and the other 2 open cases.
That silent pause isn't written in the court transcript, but you can feel it. This is a oh no moment when reality hits hard. Until now, it's all been formal talk, rights, legal steps, and procedures. But now comes a part that really matters, sentencing. Starkey has admitted he's guilty. The charges are serious. And what happens next will decide if he spends the next few years behind bars.
Will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. The court will order a pre-sentence investigation report, long form. Agent does not need to appear, but should be readily available by telephone. In case questions arise, the court is again revoking bond. We have set sentencing, and that will remain on the calendar as already previously set. Anything else we need to address here today, Mr. Schmidt?
No.
Mr. Keen?
No, Your Honor.
All right. Then he may be sent back to Polk County so he can face his revocation there and whatever's going to happen there. And then once we determine what's going to happen there, we'll figure out sentencing and how that'll come into play. All right? All right.
This part of the hearing is powerful. You can hear the pain in the victim's voice. She's a 911 dispatcher who was just trying to help, but instead, she ended up with injuries that changed her life. This wasn't just a job accident. It was a surprise attack that took away her ability to do the work she loved. The emotion in the room is heavy, and the judge is paying close attention. People don't always realize how much victim statements can affect a sentence. In this case, her words will stay in the courtroom long after she's done speaking.
We will go on the record in the matters 24 CF 91, 24 CF 109, State of Wisconsin versus Justin Starkey. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Starkey appearing in person in custody with counsel Glenn Keen. We're set today in this matter for the sentencing portion of these cases. Mr. Starkey pled guilty on March 7th, 2025 to two felony counts, one battery or threat to a law enforcement officer, and one count of, I believe it was prisoner throwing or expelling bodily substances, an I felony. The court ordered a pre-sentence investigation report. The court has received and reviewed the report. And in my review, even though I don't have as much detailed information as the counsels, the attorneys, I did not find anything that jumped out to me as being a material error or a fact that needs to be corrected. Mr. Schmidt, did you receive a copy of the PSI?
I did.
Any material facts or corrections to state on the record?
Not a correction per se, but he did get revoked in his Polk case, and they just haven't done the sentencing yet.
All right. And do you know if that matter is currently scheduled for sentencing?
It was scheduled for sentencing yesterday, but Mr. Starkey didn't have an attorney. I didn't see when they pushed it out to.
All right.
Sure, I can answer that. Scheduled for the 6th, and I work with the public defender because they'd appointed me, but I hadn't got the appointment, so I'll be representing him in that as well.
Okay, excellent. Thank you. And we are in victims' rights compliance, correct?
Yes.
Ms. Bauer, Victims' Rights Coordinator, are we going to have any victim impact statements today?
Yes, Your Honor.
How many?
One.
Just one? Mr. Keen, did you receive a copy of that PSI report?
Yes, Your Honor, and I'm not noting any material errors either.
Okay, and did you go over that report with Mr. Starkey?
Yes, Your Honor.
Did you thoroughly go over it with him?
I had a limited time because we had a phone disconnection, but I went over the main points and the recommendations.
All right, and so you went over the bulk of the main information to ensure that he can review if there are any errors?
Yes, Your Honor.
Okay. We will begin with the victim impact statement. The victim may come forward, have a seat at the black bench. Victim may state their name if they wish, or simply the initials. Yes. And if you are going to read something, please make sure that you read it slow, you enunciate your words. The court reporter needs to take everything down accurately, okay?
My name is Jan Lodermeyer.
You can sit if you wish, or you can stand, whatever you prefer.
Last name is Lodermeier. Currently, I'm 911 dispatcher for Gwinnett County. First of all, I want to thank the court for giving me this opportunity. As a corrections and communications deputy for Gwinnett County, it was my job to keep inmates safe secure, and hopefully healthy. When Justin Starkey was unresponsive in his cell the morning of 3/29/2024, sorry.
And that's okay. Take your time. You can take as much time as you need. We have the rest of the morning scheduled for this case. So if you need to stop, you need a break, you can take that time.
My partner and I at the time went into his cell to make sure he was okay, as he was unresponsive. I bent down to touch his shoulder. He didn't really respond. He started to respond. I thought he was going to sit up. He kicked me in my stomach. I went flying back into a cement wall and I fell to the cement floor. It's the last thing I ever expected from an inmate that was playing, in my mind, possible.
This wasn't just a sudden outburst of violence. It was planned in a disturbing way. Starkey didn't just throw something in the heat of the moment. He actually prepared it like some twisted experiment. He added Kool-Aid powder to the liquid to make it thicker and easier to throw. That kind of effort shows the court this wasn't an emotional slip-up. It was a cool, intentional act meant to humiliate. Prosecutors look for things like this because it clearly shows intent, and it supports giving a much harsher punishment.
To attack myself and possibly my partner in the cell. As a result of that action that day, my life has changed drastically. There's things I can no longer do. Correction officer is one of them. As my surgeon is concerned that it could happen again. Maybe yes, maybe no, but after 15 months, the doctors tell me I'm as healed as I'm gonna be. Which means constant pain, constant numbness, and sometimes tingling down my legs. As for Mr. Starkey, my anger is never going to go away. I am not a vindictive person. But honestly, I hate that man for what he has done to me.
And I'm just going to say, I appreciate your emotion. This is not a time to.
I know. That's
To
all I'm going to
attack.
say. That's all I'm going to say about that. Okay. I am no longer a corrections communications officer, deputy. I am now a 911 communications deputy. My life now is to help people that appreciate what 911 communications deputies do. And that is to help the community and save the community when we can.
Thank you. All right, Mr. Schmidt, argument and sentencing recommendation, please.
Sure. I'm going to be arguing for what the PSI recommends, which is 2 years initial confinement. Let me just make sure I say it accurate. 2 years initial confinement, 3 years extended supervision on the battery, and 1 year jail consecutive to it on the other count. So effectively, the 1 year jail gets converted into a prison sentence by way of Wisconsin statute. Mr. Starkey has 338 days credit per the jail. This is a 35-year-old man with a traumatic brain injury that was inflicted on him when he was a baby. However, his criminal history only really began within the past 5 years. The implication there is that the criminal behavior cannot be solely attributed to the traumatic brain injury. He has been placed on probation 4 times and been revoked 4 times. He was on probation when some of the conduct at stake in these cases occurred. He is not a suitable candidate for probation. He gets disability, that's been confirmed. And at one point on information belief, I believe he was also getting civil payments from the result of how his traumatic brain injury was inflicted. I do not know if he still gets payments for that today. The core behavior of Mr. Starkey in most of these cases is him assaulting and harassing correctional officers. The assaults and harassment show patterns of deliberation and planning and intention. They were not reactive or in direct response to a frustrating stimulus, such as how people might react if they have a traumatic brain injury and fly off the handle. In 24 CF 91, Justin Starkey was apparently having a seizure when COs went in to address it. You heard an account from the victim in that jail already. As soon as COs were in range, Mr. Starkey shot up and assaulted them, in particular, the full force kick of JL that caused life-altering injuries. This happened March 29th, 2024. The PSI demonstrates a lot of additional information that the PSI writer acquired contacting other jails that Mr. Starkey was in both before this incident and after. And what the PSI writer discovered was that for over a year before this and sometimes afterwards, Mr. Starkey has been in other county jails, and he has been doing the same behaviors. He has been faking seizures and medical issues to trick COs to try and come in and aid him. The jails have reacted in different ways. Eau Claire seemed to have figured out this and just wouldn't go in and expose their COs. They would see the fake seizures, document it, and then document Mr. Starkey's behaviors afterwards, which show he was clearly faking it. Sometimes his reactions have been violent to them not coming in and checking on him, say attacking the door or the cell. His assaultive behavior has also been directed at inmates in those jails. In 24 CF 248, COs came in to talk to Starkey to stop applying cleaning solution to the mirrors in the cells that they used to see in. They first tried to do it in a safe manner through the intercom. He wouldn't listen and kept doing it. The CO went in to talk with him. The CO's posture in the surveillance camera was very neutral. He was not approaching Starkey. He was just casually standing there talking. And then eventually Starkey got mad, assumed a charging posture, and charged at the deputy. It was completely unprovoked. He wasn't even touching Mr. Starkey or approaching Mr. Starkey when he was attacked. 24 CF 109, Mr. Starkey urinated.
This part is possibly the most heartbreaking and the most serious. Starkey didn't just hurt a correctional officer. He ended her career. She wasn't only injured physically. She lost a job she loved and took pride in. For a small county that already has trouble finding enough officers, that's a big loss. The prosecutor makes it clear. Starkey isn't just violent. He's a danger to everyone working to keep the jail safe. And that's a risk the court can't afford to overlook.
It on the wall and floor of his toilet and used a Kool-Aid pack, like the powder solution, to put it on it so it would soak it up to make it clumpable so you could pick it up and it would be throwable, and threw it at a deputy, a correctional officer, I should say. Again, showing deliberation and planning and really an intent to humiliate, I would say. I specifically went through the facts in these jail cases because they show something you don't really see in some of his other cases, this planning deliberative element. Mr. Starkey is intentionally using, not just in these cases, but in the descriptions of these other jails, he's using the empathy of his COs, their desire to help him and to make sure he's not having medical issues to gain access and harm them. He's using positive traits and positive things they're doing against them. It's not just immoral in that sense. It creates a broader public risk to all of the other inmates that COs have to be thinking about and be cautious of other inmates who might be faking just to gain access to harm them. It also shows this more malicious element, because this wasn't a one-off in the JL case of the faking the seizure. We see from the Eau Claire logs, this has been something he's been doing an extremely long period of time. it's a repeated plan that he keeps trying to do and presumably will keep doing in the future. I say that I presume he's going to keep doing it in the future because of how Mr. Starkey talked to the PSI writer about the correctional officer cases versus the case with his mother. The Eau Claire conviction mentioned in there is the one where he assaulted his mother in his home. So that's different than the CO ones. That was a public assault more akin to the first Burnett County case, the DC in public. And those two cases are more of the getting frustrated and attacking somebody cases. The way he talks about the case with his mother, it's because it's his mother, he says he's sorry. He says something to the PSI writer that when he's asked about whether he feels bad or sorry about what happened, he says just about his mother. He, even at the point when he was talking to the PSI writer, wasn't empathizing with any of these COs, not just the victims in our case, but really the Eau Claire ones, the other county jails where he's done this, the county jail where the CO is coming in with the medical cart, with the medicine that he needed, and he attacked them when they did it. So what am I highlighting? So I've already indicated we have to start first with considering probation. The statute requires that it should be rejected out of hand because of the failures on probation, because two of his recent convictions involved assaults in public in the community, the DC in Burnett, the Eau Claire incident with his mother. The fact he's a danger in the jail to correctional officers itself is also indicative he can't be treated in the community. That's indicative he needs a higher level of confinement, and that would be the Wisconsin state prison system. They have much better resources. They can have a better documented file and establish easier to use protocols than the county jails he's bouncing to and forth from Polk to Burnett to Eau Claire, and better establish a protocol where Mr. Starkey cannot harm officers, correctional officers. So that brings us to McCleary. Gravity offense, protection of the public, rehabilitative needs of the offender. The gravity of the offense is severe because of the maliciousness of what's happening here, and because of the pattern that can be traced back into 2023 and also forward a bit as well, of really just wanting to attack these jailers. If you look at what is the intent, what is the impetus of why he's doing this, it's not, these are not contacts where the COs are initiating contact with him. He's initiating contact with them by faking medical issues or deliberately doing something he's told not to do. He's seeking provocation. He's seeking physical contact. And as a result, he's harming COs. He's humiliating them. He's caused an injury to one CO that has prevented her from being a CO. That Mr. Starkey has robbed from the county somebody who's extremely talented and experienced in that role forever.
If you're hoping to hear an apology, don't hold your breath. When asked if he feels sorry, Starkey only gets emotional about his mother, not the officers he attacked. That lack of empathy is a big warning sign for judges and mental health experts. It suggests is not likely to change or improve. And when someone shows no remorse, the court often shifts its focus from helping them to simply making sure they don't do it again. That usually means a much harsher sentence.
We can still keep her in another role, but losing her as a correctional officer is a huge blow to our county. We're constantly trying to recruit new correctional officers because that's a hard position to get people and find people who can do it. And Mr. Starkey exacerbates a real public problem. And that's indicative of a higher gravity offense and also the nature of the injury. We need to be able to protect our correctional officers. And I think that through the gravity of the offense, through McCleary is the way we address that. Because there are not special rules for the police or for correctional officers where people can swear at them or be mean to them or throw urine at them or assault them, and they can't for the public. The COs and the deputies are also the public because they're also people, and they deserve the same respect. And they deserve the same respect for their personhood and their bodily autonomy as anybody else. Protection of the public is odd here because, like I said, most people don't think of correctional officers or police officers as the public, but they are in the sense of how that term is used. When you have an individual who's incarcerated, the public that we're seeking to protect in this case is the correctional officers. But there is also the broader public who's at danger with Mr. Starkey. One of the read-ins, the case that caused him to come into our jail to begin with, was him being public and threatening a woman who, again, was just trying to help him. With the failures on probation, with him assaulting people in public, trying to help him, with him assaulting correctional officers who really just, their main goal is to have a neutral, safe environment for all the inmates and themselves to keep everybody happy. They're not going in there and picking fights. And his disruption of peace, both in the community and the jail, indicates a strong need to protect the public that I think prison is necessary. That brings me to rehabilitative needs of this offender. Mr. Starkey, I think we see a pattern over the past 5 years where he's growing increasingly antisocial and malicious in both his behavior and his thought processes. This can't be traced to his TBI from 1991 because he doesn't have this criminal history going back to 1991. It happened in the past 5 years. They're a result of him and his choices and his behavior. We really see in the PSI, in his statements, a profound lack of empathy for people he doesn't already have a personal stake in. That's why he feels bad about his mother, but nobody else, not the woman helping him at the hotel, none of the correctional officers he's ever assaulted or thrown urine at, of which there's no justifiable reason. They demonstrate an increasingly selfish view that Mr. Starkey has, where if someone makes him angry or he feels he's not being respected, he says to the PSI writer, he's justified in what he does. That's highly concerning because it shows a lack of respect for others, a lack of respect for bodily autonomy, which is really one of the cornerstones of modern society. If his empathy is non-existent to this extent, if he's this selfish in his worldview, if his locus of control is...
Yes, you heard that right. Starkey admitted that he purposely threw urine at a corrections officer. Gross? Definitely. But it's also a serious crime in Wisconsin. It's legally called prisoner expelling bodily substances, and it's a felony. This kind of act isn't just nasty or rude. It's a health risk and a violent attack. The courts take it very seriously, especially when it's aimed at jail staff.
Internalized. What that means is we have to rely on punishment to deter his behavior. There's no other choice because the decision to change isn't going to come organically from Mr. Starkey. He's been continually assaultive for years now in these jails. So it has to come from fear of punishment. It has to come from deterrence. If we don't address punishment through the criminal justice system in that manner, my big concern with the implications of how Mr. Starkey talks about his TBI and his ADHD is he's going to come to the conclusion that so long as he ties things back to that or medical issues and he doesn't get punished, then it's going to reinforce the behavior. If he's able to use those diagnoses as an out to avoid punishment, then he's being told, you can still do that because of your condition. And I take specific umbrage at that in particular, because there's a lot of people out there with TBIs, with ADHD, and other conditions. These don't apply to Starkey in particular, like schizophrenia or bipolar, conditions that can cause a person to behave erratically or become violent or aggressive. And a lot of these people, most of these people, don't get assaultive. They don't have criminal histories. They aren't attacking people in jails. They're not even in jails because they're still capable of having free will. They can still make the choice to, hey, I want to better myself. I want to get along in society. I want to treat my condition. I want to be responsible. They're not playing up their injuries. They're not playing up their illnesses. They're being responsible members of society. And there's no reason Mr. Starkey can't either. Prior to 5 years ago, that's what he was. I asked the court not to reinforce that behavior. I asked the court to do a prison sentence to deter it.